It's 1 o'clock. What's going on here on LaGuardia Web Radio, WLGR? Today, we've got something special for you, which is a rebroadcast of our series, May It Please the Court, in light of the leaked documents and the pending SCOTUS decision in Dobbs versus Jackson Women's Health. We're going to be airing the episode of the 1973 case Roe v. Wade. And this features a discussion by Professors Vera Albrecht and Shannon Proctor, who both teach the philosophy of law class in the humanities department. We've made all of our episodes from May It Please the Court available on a unique playlist on our YouTube archive. And you should know that whether you're a fan or not, that all of the cases that we've been dealing with all deal with reproductive rights. The genesis for the notion of these broadcasts was my exposure to this collection of recordings of Supreme Court oral arguments on decisions, from the history of the court. And after trying to find a constitutional law attorney in CUNY who might want to do the show, I realized I had all the talent I needed here at the college. Starting with Dr. Albrecht, who I've worked with many years, and knowing that she teaches philosophy of law, and then Shannon Proctor. And Sherry Carr, who's the coordinator of philosophy, has also worked to bring us other folks, including Chelsea Del Rio, who's worked with us in the past. So, again, the notion for these broadcasts were to try to get some sort of understanding into some pretty complicated arguments. When you listen to these recordings, some of the arguments are very esoteric. If you're not an attorney, you might not necessarily know what they're talking about. I wanted to bring in experts to help me understand some of the different points of view that the attorneys bring up in their oral arguments. But now that we have this and they are available on the archive here at LaGuardia Web Radio WLGR, the notion is that faculty and students can utilize these for their own purposes, particularly, let's say, in a critical thinking course or philosophy course, to listen to the oral arguments and let students make their own decisions or listen to what faculty might say about this. And I believe that Dr. Carr has already started doing that in some of her courses. So again, like all recordings at LaGuardia Web Radio WLGR, it not only is, it'll be available on Twitch for the next 2 weeks, this particular recording, but then they will also end up in the YouTube archive as well as our SoundCloud audio archive, and eventually in the institutional archives that are overseen by Professor Cleary in the library in perpetuity. And who knows if someday somebody will listen to these and see some of the things that we were doing here. Roe v. Wade is close to 50 years. A 50-year anniversary of the decision, and as we know, those who have lived us through this time, it is a case that we've gone to over and over again, and we are not surprised that, given a lot of the conflict that's going on in the executive, legislative, and also judicial branches of our government, that this is a case that we're dealing with today. So without further ado, I'll turn it over to my engineer, Mr. Pope, who will play the recording, and then I will check in at the end with just some last remarks. So take it away, Mr. Pope. Welcome to What's Going On. I'm your host, Hugo Fernandez, here on LaGuardia Web Radio, WLGR. And today's a special show, hopefully one of many to come. It's based on a series of recordings called May It Please the Court, which are transcriptions of oral arguments in Supreme Court hearings. Today, a very provocative one, Roe v. Wade, the landmark case that made abortion possible federally across the United States, though now in many states they're trying to reverse that. And my guests today, they're going to help me, help us understand this, are two doctors who teach the philosophy of law. So I'm very excited to have them both here on the show, Dr. Vera Albrecht and Dr. Shannon Proctor. Say hello. You got to unmute yourselves. So
hi, everybody.
Shannon's got a cold, so
Yeah, please forgive me. Hello, and thank you, Hugo, for having us on today.
You got it. And I want to give you guys a chance to introduce yourselves before we go to the recording. So just to let folks know, we'll just do the introductions, talk just for a minute, and then we're going to play the oral arguments with a PowerPoint that I put together, so you can see the images of people who were speaking at the time of the case. And then we're going to come back probably at the half-hour mark and then begin to start talking a little bit about in depth into some of the philosophy of law in the cases. But who would like to start with a little brief introduction about yourselves as far as, your backgrounds, your education, and some of the things you do here at LaGuardia?
Okay, let me start then. I'm Vera Albrecht. I'm originally from Germany, as you can tell by my accent that I can't get rid of. I got most of my education in Germany, and I have a PhD in philosophy, so I don't have a law degree, but I teach philosophy, and philosophy of law being kind of a special field as a subfield, so to speak, of social and political philosophy. And again, neither Shannon nor I were lawyers, so don't ask us if you have any problems with your landlord. So we're doing the philosophy of law, very basic questions about justice, right and wrong in the legal field. And this specific one would be a constitutional issue, as we're talking about this Supreme Court decision. I don't know this. I'll leave the rest to Shannon. Yeah.
Okay, thank you. I don't know about the rest of it, but I'll do my part. I'm Shannon Proctor. Just like Vera, I have a degree in philosophy where I focused on social and political philosophy, and as a subspecialty did teach and learn about the philosophy of law when I was in graduate school. I teach the philosophy of law class here at LaGuardia Community College. And I'm really interested in today's discussion because it maps onto something that we talk about a lot in my class, which is, should the law enforce morality, or where is the line between what is morally obligated or allowed and should be legally obligated or allowed. And the issues of privacy that are going to come up in this conversation, I think, are a great way to think about that distinction between the law and morality. So I'm really hopeful that we get some exciting questions, and excited to hear what Hugo and Vera have to say about this too. So thanks again.
Well, I brought you on the show so you could tell me, because I got to tell you, when I used to listen to this stuff years ago, my ex-wife was an attorney and she had this set. It gets so heady, it's very hard for me to make sense of things. And then this is one of those cases too where there's very tough questions. But I think that's enough to get us started, and I'm going to turn it over to our engineer, Mr. Pope, who is going to play the audio and also simultaneously try to keep it, show us the PowerPoint that was created. This is the first time we've ever done this, so forgive us if it's a little messy. All right, take it away, Mr. Pope.
May it please the court presents oral arguments in Roe versus Wade.
We'll hear arguments in number 18, Roe against Wade.
This is Peter Irons. We're in the chamber of the United States Supreme Court in Washington, D.C. It's December 13th, 1971. Chief Justice Warren Burger has called a case that raises an unsettled and unsettling issue in American society, abortion. Only 7 justices sit behind the bench. 2 longtime justices, Hugo Black and John Harlan, died recently and have not yet been replaced. Lawyers, reporters, spectators pack the courtroom. Sarah Weddington argues for Jane Roe.
Mrs. Weddington, you may proceed whenever you're ready.
Mr. Chief Justice, and may it please the court. Certainly Jane Roe brought her suit as soon as she knew she was pregnant, as soon as she had sought an abortion and been denied. She came to federal courts. She came on behalf of a class of women, and I don't think there's any question but that women in Texas continue to desire abortions and to seek them out outside our state.
In 1970, an unmarried pregnant woman, using the pseudonym Jane Roe, sued Henry Wade, the Dallas, Texas district attorney. Two young lawyers, Sarah Weddington and Linda Coffey, asked the federal court to declare unconstitutional the Texas criminal law prohibiting any abortion not intended to save the mother's life. They also sought to bar the district attorney from enforcing the law. The federal judges ruled that the Texas law violated the Ninth Amendment to the U.S. Constitution, which reserves to the people those rights not granted to the states, but the judges declined to block enforcement of the law. Both sides appealed to the Supreme Court. Sarah Weddington is making her first argument to the court.
In Texas, the woman is the victim. The state cannot deny the effects that this law has on the women of Texas. Certainly there are problems regarding even the use of contraception. Abortion now for a woman is safer than childbirth. In the absence of abortion or legal, medically safe abortions, women often result to the illegal abortion, which certainly carry risks of death, all the side effects such as severe infection, permanent sterility, all the complications that result. And in fact, if the woman is unable to get either a legal abortion or an illegal abortion in our state, she can do a self-abortion, which is certainly, perhaps by far the most dangerous, and that is no crime.
Weddington said that Texas allowed no abortions if pregnancy did not endanger a woman's life.
If the pregnancy would result in the birth of a deformed or defective child, she has no relief. Regardless of the circumstances of conception, whether it was because of rape, incest, whether she is extremely immature, she has no relief.
She moved on to the law's impact on women.
I think it's without question that pregnancy to a woman can completely disrupt her life. It disrupts her body, it disrupts her education, it disrupts her employment, and it often disrupts her entire family life. And we feel that because of the impact on the woman, this certainly, in as far as there are any rights which are fundamental, is a matter which is of such fundamental and basic concern to the woman involved that she should be allowed to make the choice as to whether to continue or to terminate her pregnancy.
Justice Potter Stewart shifted the discussion to constitutional issues.
Mr. Weddington, so far on the merits, you told us about the important impact of this law, and it's made a very eloquent policy argument against it. I trust you are going to get to what provisions of the Constitution you rely on, because, of course, we'd like to sometimes, we cannot here be involved simply with matters of policy, as you know.
Your Honor, in the lower court, as I'm sure you're aware, the court held that the right to determine whether or not to continue a pregnancy rested upon the Ninth Amendment, which, of course, reserves those rights not specifically enumerated to the government, to the people. I do feel that that the Ninth Amendment is an appropriate place for the freedom to rest. I think the 14th Amendment is equally an appropriate place under the rights of persons to life, liberty, and the pursuit of happiness. I think in as far as liberty is meaningful, that liberty to these women would mean liberty from being forced to continue the unwanted pregnancy.
You're relying in this branch of your argument simply on the Due Process Clause of the 14th Amendment?
We had originally brought the suit alleging both the Due Process Clause, the Equal Protection Clause, the Ninth Amendment, and a variety of others.
And anything else that might have been.
Yeah, right.
Sarah Weddington responded with this concise statement.
One of the purposes of the Constitution was to guarantee to the individual the right to determine the course of their own lives.
Justice Byron White pressed the troubling question of how far the right to an abortion would go.
Will that take you right up to the time of birth?
It is our position that the freedom involved is that of a woman to determine whether or not to continue a pregnancy. Obviously, I have a much more difficult time saying that the state has no interest in late pregnancy.
Why is that?
I think it's more the emotional response to a late pregnancy rather than it is any constitutional.
By whom?
I guess by persons considering the issue outside the legal context. The Constitution, as I see it, gives protections to people after birth.
Sarah Weddington sat down at the counsel table with Linda Coffey. Texas Assistant Attorney General Jay Floyd began with an attempt at humor.
Mr. Chief Justice, may it please the court. It's an old joke, but when a man argues against two beautiful ladies like this, they're going to have the last word.
No one laughed. Chief Justice Burger looked annoyed. After an embarrassed silence, J. Floyd argued that the case was moot because Jane Roe was no longer pregnant. One of the justices pushed Floyd.
What procedure would you suggest for any pregnant female in the state of Texas ever to get any judicial consideration of this constitutional claim? Your Honor, let me answer your question with a statement, if I may. I do not believe it can be done. There are situations in which, of course, as the court knows, no remedy is provided. Now, I think she makes her choice prior to the time she becomes pregnant. That is the time of the choice. It's like more or less, the first 3 or 4 years of our life, we don't remember anything. But once a child is born, a woman no longer has a choice. And I think pregnancy may terminate that choice as well. Maybe she makes her choice when she decides to live in Texas.
Floyd's claim that no woman could challenge the Texas law prompted more questions.
In a constitutional case of this kind, it becomes quite vital sometimes to rather precisely identify what the asserted interest of the state is. The protection of the mother at one time may still be the primary, but the policy considerations, and this just would seem to me to be for the state legislature to make a decision. Certainly that's true. Policy questions are for legislative and executive bodies, both in the state and federal government. But we have here a constitutional question, and in deciding it, assessing it, it's important to know what the asserted interest of the state is in the enactment of this legislation. I am, and this is just from I speak personally, if I may. I would think that even when this statute was first passed, there was some concern for the unborn fetus. When was it enacted? I believe it was 1859 was the original statute. This, I believe, was around 1907.
Justice Thurgood Marshall and J. Floyd debated the question of when life begins.
We say there is life from the moment of impregnation.
And do you have any scientific data to support that?
Well, we begin, Mr. Justice, in our brief with the development of the human embryo, carrying it through to the development of the fetus from about 7 to 9 days after conception.
Well, what about 6 days?
We don't know.
But the statute goes all the way back to 1 hour.
I don't, Mr. Justice, there are unanswerable questions in this field.
I appreciate it.
This is an artless statement on my part.
I withdraw the question.
Thank you. Or when does the soul come into the unborn? If a person believes in a soul, I don't know.
J. Floyd argued that the justices had nothing to decide.
There is nothing in the United States Constitution concerning birth, contraception, or abortion. We think these matters, the matters of policy, should be properly addressed by the state legislature.
After oral argument, the justices discuss and vote on cases behind the closed doors of the court's conference room. On rare occasions, the court does not decide a case and schedules further argument. Roe v. Wade was one of these cases. The court does not disclose its reasons. Perhaps the justices felt that such an important and controversial issue as abortion deserved a vote by the full court of 9 justices. On October 11, 1972, when the argument resumed, Lewis Powell and William Rehnquist had joined the court. Sarah Weddington returned for Jane Roe. She had stumbled in her first argument on the constitutional basis for abortion rights. She tried now to repair the damage.
In our original brief, we alleged a number of constitutional grounds. The main one that we are relying on before this court are the 5th, the 9th, and the 14th Amendments. There is a great body of precedent. Certainly we cannot say that there is in the Constitution so stated the right to an abortion, but neither is there stated the right to travel or some of the other very basic rights that this court have held are under the United States Constitution. The court has in the past, for example, held that it is the right of the parents and of the individual to determine whether or not they will send their child to private school, whether or not their children will be taught foreign languages, whether or not they will have offspring, the Skinner case, whether the right to determine for themselves whom they will marry, the Loving case. Griswold, of course, is the primary case, holding that the state could not interfere in the question of whether or not a married couple would use birth control. And since then, this court, of course, has held that the individual has the right to determine whether they are married or single, whether they will use birth control. So there is a great body of cases decided in the past by this court in the areas of marriage, sex, contraception, procreation, childbearing, and education of children, which says that there are certain things that are so much a part of the individual concern that they should be left to the determination of the individual.
Weddington pointed to New York State, which repealed its law against abortion in 1971.
There have been something like 1,600 Texas women who have gone to New York City alone for abortions in the first 9 months of 1971. The overall maternal death rate from legal abortion in New York dropped to 3.7 per 100,000 abortions in the last half of 1971, and that in fact is less than half the death rate associated with live delivery for women. That in fact the maternal mortality rate has decreased by about 2/3 to a record low in New York in 1971.
These facts did not satisfy Justice Byron White. He asked if it were critical to the case that the 14th Amendment did not protect a fetus.
If the state could show that the fetus was a person under the 14th Amendment or under some other amendment or part of the Constitution, then you would have the situation of you would have a state compelling interest, which in some instances can outweigh a fundamental right.
Justice White exploited her concession on this crucial point.
Well, do I get from this then that your case depends primarily on the proposition that the fetus has no constitutional rights?
It depends on saying that the woman has a fundamental constitutional right and that the state has not proved any compelling interest for regulation in the area. Even if the court at some point determined the fetus to be entitled to constitutional protection, you would still get back into the weighing of one life against another.
That's what's involved in this case? Weighing one life against another?
No, Your Honor. I said that would be what would be involved if the facts were different and the state could prove that there was a person for the constitutional right.
Well, if it were established that an unborn fetus is a person within the protection of the 14th Amendment, you would have almost an impossible case here, would you not?
I would have a very difficult case.
You certainly would.
Assistant Attorney General Robert Flowers replaced J. Floyd at the podium. Flowers jumped on Weddington's concession about fetal rights, but encountered a quizzical Justice Harry Blackmun.
It is impossible for me to trace within my allocated time the development of the fetus from the date of conception to the date of its birth. But it is the position of the state of Texas that upon conception we have a human being, a person within the concept of the Constitution of the United States and that of Texas also.
Now, how should that question be decided? Is it a legal question, a constitutional question, a medical question, a philosophical question, a religious question, or what is it?
Your Honor, we feel that it could be best decided by a legislature in view of the fact that they can bring before it the medical testimony, the actual people who do the research. But we do
have... You think it's basically a medical question?
From a constitutional standpoint, no, sir. I think it's fairly squarely before this court. We don't envy the court for having to make this decision.
Flowers faced the same question Justice White posed to Weddington of balancing lives.
You're correct that the fetus is a person. Then I don't suppose the state would have great trouble permitting an abortion, wouldn't it?
Yes, sir.
In any circumstance?
It would, yes, sir.
To save the life of the mother or her health or anything else?
Well, there would be the balancing of the two lives, and I think that...
What would you choose? Would you choose to kill the innocent one or what?
Well, in our statute, the state did choose that way, Your Honor.
Well...
in the protection of the mother.
Flowers pressed ahead, but encountered sharp questions.
Gentlemen, we feel that the concept of a fetus being within the concept of a person, within the framework of the United States Constitution and the Texas Constitution, is an extremely fundamental thing.
Of course, if you're right about that, you can sit down. You've won your case.
Your Honor...
except insofar as maybe the Texas abortion law presently goes too far in allowing abortion.
Yes, sir. That's exactly right. We feel that this is the only question, really, that this court has to answer. We have
You think the case is over for you? You've lost your case then. If the fetus or the embryo was not a person, is that it?
Yes, sir. I would say so.
You mean the state has no interest of its own that it can assert?
Oh, we have other interests, Your Honor. Preventing promiscuity, say.
Justice Marshall pushed Flowers harder.
I want you to give me a recognizable medical writing of any kind that says that at the time of conception, that the fetus is a person.
I do not believe that I could give that to you without researching through the briefs that have been filed in this case, Your Honor.
Flowers' arguments that the fetus was a person under the Constitution and that abortion was a legislative, not a judicial issue, provoked another round of questions.
If you're right that an unborn fetus is a person, then you can't leave it to the legislature to play fast and loose with that, in dealing with that person. In other words, if you're correct in your basic submission that an unborn fetus is a person, then abortion laws such as that which New York has is grossly unconstitutional, isn't it?
That's right. Yes.
Allowing the killing of people.
Yes.
Of persons.
Your Honor, the Massachusetts, I might point out...
You can't leave this up to the legislature. There's a constitutional problem, isn't it?
Well, if there would be any exceptions within this...
And the basic constitutional question initially is whether or not an unborn fetus is a person,
yes,
isn't it?
And entitled to the constitutional protection.
That's critical to this case,
yes,
sir,
it is.
Flowers ended with these words.
I think that here is exactly what we're facing in this case, is the life of this unborn fetus paramount over the woman's right to determine whether or not she shall bear a child. This court has been diligent in protecting the rights of the minorities. And gentlemen, we say that this is a minority, a silent minority, the true silent minority. Who is speaking for these children? Where is the counsel for these unborn children whose life is being taken? Where is the safeguard of the right to trial by jury? Are we to place this power in the hands of a mother and a doctor? All of the constitutional rights. If this person has the person concept, what would keep a legislature under this grounds from deciding who else might or might not be a human being or might not be a person?
In her rebuttal, Weddington stressed the significance of the decisions that faced both pregnant women and the 9 men on the Supreme Court bench.
No one is more keenly aware of the gravity of the issues or the moral implications of this case, but it is a case that must be decided on the Constitution. We do not disagree that there is a progression of fetal development. It is the conclusion to be drawn from that upon which we disagree. We are not here to advocate abortion. We do not ask this court to rule that abortion is good or desirable in any particular situation. We are here to advocate that the decision as to whether or not a particular woman will continue to carry or will terminate a pregnancy is a decision that should be made by that individual. That in fact she has a constitutional right to make that decision for herself, and that the state has shown no interest in interfering with that decision.
Chief Justice Berger.
Thank you, Mrs. Weddington. Thank you, Mr. Flowers. The case is submitted.
3 months later, the Supreme Court decided Roe v. Wade. On January 22, 1973, by a vote of 7-2, the justices struck down the Texas law and upheld a constitutional right to abortion. Justice Harry Blackmun, who once considered becoming a doctor, wrote the majority opinion. Blackmun acknowledged the emotional nature of the abortion controversy, but the court's task, he said, was to resolve the issue by constitutional measurement, free of emotion. He found that yardstick in the 14th Amendment's concept of personal liberty, which included a right to privacy, he said, broad enough to encompass a woman's decision whether or not to terminate her pregnancy. The central issue in the arguments and the court's opinion focused on whether the fetus was a person and thus protected by the Constitution against deprivation of life. If this suggestion of personhood is established, Blackmun said, Jane Roe's case collapses. Sarah Weddington conceded as much on re-argument, he noted. On the other hand, Robert Flowers could cite no case holding that a fetus was a person. Consequently, the court would only consider the rights of pregnant women to an abortion. But this right was not absolute. As the fetus grew toward viability, able to live outside the womb, the state had a legitimate interest in protecting it. Blackmun divided pregnancy into trimesters, or 3-month periods. During the first, states could not interfere with the abortion decision. States could regulate abortion procedures during the second trimester, and abortion could be prohibited entirely during the last 3 months of pregnancy. Justices Byron White and William Rehnquist dissented in Roe v. Wade. Rehnquist denied that the Constitution contained a privacy right. Abortion laws, he wrote, are the kind of social and economic legislation that elected lawmakers should vote on. White argued for fetal personhood and accused the majority of an exercise of raw judicial power. Since 1973, political battles over Roe v. Wade have prompted dozens of state efforts to restrict abortions. Ruling in cases from Missouri and Pennsylvania, the court in 1989 and 1992 upheld laws that restricted access to abortion. The justices now face state laws that ban almost all abortions. This will force a decision on whether to overrule Roe v. Wade entirely. Sarah Weddington and the state's lawyers spoke to the Supreme Court for 2 hours about abortion. Since then, Americans have spent thousands of hours in passionate argument on this issue. The arguments we heard only began a process of decision the court and the country have not yet concluded. This is Peter Irons.
Okay, so we're coming out of the recording. It's you're watching what's going on here on LaGuardia Web Radio, WLGR. I'm your host, Hugo Fernandez. My guests today are Doctors Vera Albrecht and Dr. Shannon Proctor of the Humanities Department's Philosophy Program, who both teach the philosophy of law. And, I'm holding back the joke, which is the one thing I wanted to abort was that slideshow because... my reach exceeds my grasp. I didn't give our engineer enough time to rehearse it, and we'll do better next time, folks. So, doctors, do you have some initial thoughts on listening to the oral arguments? Who would like to start?
I guess one thing I wanted to say is having read it recently and then listening to it, it really does add another, an important dimension. And I did think your slideshow was as bad as you're saying it was. It was also nice to see the different faces, right? It gives more context, and it made it a more meaningful experience than just reading through.
Right.
The case.
Also, hearing the voices, it has different emphasis if you hear the voices. Also, if I may just add, I said this earlier before we were on the air, that the pictures and the voices really show how long time this is ago. I mean, to me, probably
50 years, right?
even more so. This sounds, wow, the black and white and the quality of the recordings of the voice seems very long time ago, and it's pretty amazing. It baffles me that what was a controversial issues in the 1970s would still now be such a controversial issue, and we may see uh, more abortion rights discussion in the Supreme Court now that the Supreme Court is differently staffed, especially with the most recent nomination and filling of the court with Judge Barrett, and who is an outspoken anti-abortionist.
Oh yeah, I was going to say that it's a Texas case, and I looked it up, and there are more challenges going on now in Texas to it than ever before. But Dr. Proctor, you wanted to chime in?
Yeah, I was going to say this is actually one of the interesting things that's gone on in scholarship since, even from pro-choice circles, is to question whether going this route to legalize abortion through the Supreme Court, as opposed to trying to go through state legislatures to get these rights encoded, like perhaps these debates would have been more sorted had there been a different route, because the use of privacy to sort of codify these rights has not been well accepted by even people who absolutely support the right for women to choose.
Seems like the crux of the argument falls on the question of when life begins and when does it need to be protected. Because I was reading the written decision. I'm not a good student, so I didn't read all my homework, right? But I was reading a little bit of Blackmun's written decision. Obviously, the notion that people you would, by not allowing legal abortion, you prevent promiscuity. That was thrown out as a reasoning, or this idea that it's dangerous to the woman, which now it is not. So it really still falls on this question of when does life begin? You are philosophers. Do you want to weigh in on that? Dr. Albrecht's saying no, that's not the crux of the argument.
No, it's not when life begins, when a personhood begins. And I mean, it's nobody questions when life begins, because we routinely kill, animals for our dinner. So this is not a question about life itself. It's about, if anything, life or personhood. And I think that's something that really stuck out in this decision. And I do know that it was an issue, but the interesting thing, it was really brought up or introduced by Weddington to say, well, if the state could show that the fetus is a person. So she started this whole discussion about personhood, which I think was maybe a big mistake that she did.
In the first part of her argument, in the beginning?
In the first part of her argument, right. And of course, she probably realized it. And all the way through the discussion, it was an issue about personhood. And I think she turned it away from this. And it is not so much an issue about personhood, but an issue about who can decide. Which it really is. And I think the whole issue of personhood is misleading. And if anybody wants to question this, I will say more.
I actually really think you can't be concerned about the personhood issue without dealing with the privacy and states' rights issues as well. The whole reason the personhood question comes up is, right, do states have the right to ban abortion, right? And so this is a states' rights issue. Well, the states don't have the rights if it's a liberty issue. But if it's a liberty issue, a constitutional issue, and if it's a constitutional issue, then you automatically get into the personhood issue, because then it looks like it's a battle between two persons' rights. The problem is, in having taught the medical ethics course at LaGuardia as well, and looked at this issue of personhood, it's not resolved in medicine at all in the Western world. This is not a resolved question. This is really a philosophical question about when personhood begins. So, sorry.
Right. By the way, when you move around, there's some sort of sound. Do you have a hanging mic, or do you have a lot?
You know what it is?
Like
I'm
mine.
moving. You can hear these, so I'll try to just sit as still as possible.
Speak still. So they put it on. I mean, again, because it's constitutional, they go back to the 5th, the 9th, and the 14th Amendment, which I tried to, uh, one of the things that was going on behind the scenes is I was texting Chris the whole time and saying, like, no, slide this one, slide that one. So the 14th Amendment, which was what I had wanted, what we left on is, nor shall any state deprive any person of life, liberty, or property without due process of law, nor deny to any person within its jurisdiction the equal protections of the law. Maybe that's the wrong section of the 14th Amendment, but it seemed that was this liberty question. I mean, the premise of why abortion is legal is, and we stand on this, is that it is a woman's right to decide. It is her body. And until the child came out, though, Blackman did divide it up by trimesters. And I was reading a little bit about that in the decision. Why do you think it matters in the trimesters? You want to talk about that?
The question is about viability, right? The question is about, could the fetus survive outside of the womb?
Right.
And then it looks like that gives more of an answer to the personhood question. Oh, it really is hard to sit still and be quiet and talk at the same time.
We're gonna get you a new headset.
I know that this is the discussion, actually, Shannon, you're right. Is the fetus, at which point is the fetus viable? Certainly in the last trimester, outside the womb, but in the big picture, and I think, and it might be a good thing, it's a question of development. How developed is the fetus? But I think it still takes away from the question. So some states, and of course now, and even back then, it's if the mother's life is, it's threatened, then an abortion would be allowed. And in fact, then even late state abortions are allowed. But in this case also, we kind of do not consider as to whether the fetus is a person or not. This personhood, then you would say, why do you decide between two persons? Why not decide in favor of the fetus, for that matter, right? I mean, that's almost arbitrary if there is personhood.
Well, I mean, I guess, though, I would say there's some feminist theorists who've certainly argued against this, right? Like the recently deceased, I can't remember now if it's Thomas or Thompson. That's terrible. Judith Jarvis. Yeah, like
it's
one
Thompson.
question. Thank you. Yeah. There's one issue that comes up. There is, you're not just pitting two lives against each other, because one of those lives is required to maintain the other, right? There's this additional layer. It's not as if it's pitting the two of us against each other, right? It's saying, what would it be like if your life was required, if your body had to be given up for me to be able to survive? And can the court do that? The court can't make me give you an organ, even if that's the only thing that will allow you to stay alive, right?
Yeah. And I think this is why the whole personhood question is a little off in general, because it is, if you need my kidney for your survival, right, you can say, oh, well, Shannon needs my kidney. Can I be forced to hook you up to me, or you have to walk next to me for the next 20 years and I support your life? Of course, that's the question of liberty. And I think this should have been the focus to begin with in this whole decision, I think oddly, and I wasn't really that aware of it, that Weddington herself brought this issue in. She opened that little personhood question door, of course, unsuspectingly, but that really should not be the question.
Yeah, and I think actually what helped her out is the fact that the court did decide to wait until they had a full complement of 9 justices, which worked in her favor. It gave her time to change very dramatic change. I just want to say we were at the quarter hour before the end of the show, and I wanted to, if Dr. Riccio, who's manning the Twitch stream, has any questions she'd like to forward, she should feel free. But since she hasn't already, I wonder if there are any. I was looking at the Ninth Amendment too when you were talking about one or the other, and there it talks about the enumeration in the Constitution of certain rights shall not be construed to deny or disparage others retained by the people. So again, it's this thing that the right of the fetus would not override the rights of the mother carrying the fetus at the time,
Well,
right?
also right there, I think, I mean, I'm certainly not a constitutional scholar, but as my understanding is historically, there was some fear that enumerating in the Bill of Rights, that stating these rights, there was fear that that would be read as these were the only rights. And so the ninth gets used, right, to say just because it has not expressly been put out in the Constitution, that doesn't mean it is automatically not a right that citizens retain.
Right. The penumbras or these other laws that come from laws. I just want to read this, and let me see. This is a lesson to all of you. I know Dr. Albrecht had her class watch. Might have asked her class to watch this, so I want to teach you a little one. Oh, wait a minute. There are a lot of comments here. So, but there's a question in from the Twitch stream, so let's give it to you guys. It says, whose liberty is protected under the Constitution because one needs the other?
Mm-hmm.
Do you want to answer that?
Do you want to answer, Shannon?
My understanding is that because, if this is maybe another feminist issue to raise, because of who created the Constitution, motherhood, fetuses, childbirth, none of this was discussed. This did not come up in the Constitution. So this is where the justices were having such a hard time.
Mm-hmm.
They don't know because it's not.
It was a room full of men in the first case when they wrote it.
Forgot that,
and there's but there was still a room full of men. I mean, Weddington and Coffey were the only women in the room while this was argued. But another question is, a fetus isn't exactly an organ, and does a fetus have no rights since all persons have a life to liberty? I think this one's someone.
That's a good question, but here also, and I think that's one of my really good students in my law class, if I guess this correctly.
Do you want me to tell you? So, I've got a handle. Do you want to know who it is?
I can see. I can't see that. I need to see the chat name, but I have a feeling. So you're absolutely right. The fetus isn't exactly an organ, right? So it's not like the fetus isn't identical with the uterus or something. But then here also, does the fetus have no rights since all persons have a life to liberty? The question here is, of course, in the question you assume that the fetus is a person if all persons have a right to liberty. The question is, of course, here, is the fetus a person? And I find, I'm gonna right to life. Yeah, right to life. Doesn't the fetus have? If the fetus is a person, I'm gonna say something that's gonna that you will all find very offensive, and I'll say it just for the sake of it.
About time, because usually nobody says this.
Nobody raises that question of personhood when we kill the cow for the sake of a hamburger, right? And I know it's offensive now, but if we say, well, is the cow a person?
Can I ask a more offensive question, possibly, or at least a more troubling one? And this is something I've seen in the literature. We don't seem to worry about it when we're talking about, let's say, the expulsion of sperm in other avenues.
That is, sounds like Legally Blonde.
I don't know if we should all be offended by what Hugo just said, but right. So this issue is if the fetus is a person, then why isn't the individual sperm cell and egg, which have the same potentiality for life as a zygote, right? Like, so where this is one of the things philosophers love to do is this line drawing debate, right? Why is it that once they've come together, this is a problem, but let's say if we use birth control or other means, that's not a life, even though it has a similar potentiality for life as sort of a, a new zygote would.
That's the
So,
argument of the Catholic Church,
The,
or at least
okay,
that's
the
the argument
argument
allowed.
of the Catholic Church is that it's a different thing because there you have, and I mean, in modern terms, you have genetically the potential to to life. So it's that ultimate goal. It will be a human, but I mean, I just raised that kind of right to life question with regard to animals because we have no problem raising this question. Or it's already a question with regard to the fetus. We do not ask these questions with regard to animals that we eat. And what Shannon just said, what exactly makes this the different moment? And I think one of the judges actually went back and challenged the Flowers, I think it was, and said, when exactly, why, I mean, if you say 6 hours, why not 5? Why not 1 hour? Why not 1 minute? Why not 1 second? So this is problematic, right? So
There's a last question here that might be our last question that we might want to touch on, which is, do you think the court settled the issue of abortion?
no.
Why do you say that? Why do you think it's not settled? Because the people are challenging it?
I think if you look at how much debate has gone on, as Vera was pointing out, that this was decided in 1973, that there is still tremendous debate. I know, and I'm sure it's similar in any of our philosophy classrooms. When this topic comes up, it is immensely debated. There has not seemed to be a lot of movement in resolving the privacy issues, the personhood issues, the competing person issues. Those just don't seem well resolved.
Dr. Albrecht?
yeah, I think it was. I mean, of course, technically, of course, it was resolved because this decision stands unless the Supreme Court says otherwise. States cannot make abortion illegal as long as this particular decision stands. But there's a good chance it will come up again. So, and just before the show began, we said, well, in the early 2000s, it looked like, okay, this is really done and over. Nobody's gonna, abortion is kind of just an old issue. But it became more of an issue, and it is very much also a philosophical issue because people think of it very much in terms of morality. Those people who are, and it's really that kind of long-standing battle between what is kind of morally wrong and that the law should kind of tell people to act in a certain way versus the protection of individual rights, which is, of course, the pro-choice stance that it is the woman's right to make that decision. And it's also odd, if you really think about it, that a woman can perform a self-abortion without it being legal. And that seems almost an odd issue here, but I don't want to open another door. But yes, there's a chance that this will come back to the Supreme Court.
I think we're going to have to leave it at this. I mean, the one comment I make whenever this comes up, because I'll admit I'm divided on the question, is that I feel that a lot of the folks who say they are pro-life are really just pro-birth, because it seems like once the children are born, they're not very interested in taking care of them for the rest of their lives. We at least as a society are not prepared to do that. So I would, if for all those folks who are pro-birth, I wish they would put as much energy into supporting the lives that do come into this world who may have not been planned for, and though they decide to go to full term and have the child, but we don't take care of our children. But we got to end it here. Though we might want to think about part of the format of the show is making it a little bit longer to allow for even more debate. particularly because students have been chiming in some questions that are good. And I think this is
Yeah.
something I'll keep going. But I just want to thank my guests today for trying to do the impossible, which is to talk about this difficult question. Dr. Vera Albrecht and Dr. Shannon Proctor of the Humanities Department's philosophy program. And, if you want to keep having this debate, take their class.
Exactly.
The philosophy of law, the philosophy of medicine. Is it
Medical ethics.
Medical
Just
medical
yeah.
ethics? Yes.
Yeah.
Which I believe Dr. Carr teaches as well.
Mm-hmm.
And any last words from the two of you before we?
Just thanks for inviting us. It's great to have a real kind of philosophical debate in these times, right? It's nice to get on Zoom and use some of those muscles.
That's all we do. That's all we do here, Dr. Proctor. Come back.
Yeah. Well, thanks
Dr.
for bringing up this important discussion. And yeah, thanks all students of you. And sorry we couldn't answer all your questions that were in the chat. There were a number of really great questions in the chat, but yeah, thanks for tuning in. And this conversation will certainly continue.
And I want to thank my engineer, Mr. Pope, for doing his best. Obviously, I need to get him the PowerPoint sooner so he can have a chance to rehearse. Dr. Riccio for manning the stream. And Mr. Pope, take us out with our outro will be the other side of the question. And thanks to everybody for listening. The show is What's Going On. I'm your host, Hugo Fernandez, here on LaGuardia Rib Radio WLGR. Bye-bye.
Thank you. Bye-bye.
Okay, so that was the show. And what you're watching is a rebroadcast of our series, May It Please the Court. In light of the leaked documents from the pending SCOTUS decision in Dobbs versus Jackson Women's Health, we've aired an episode of the landmark 1973 case Roe v. Wade, which featured a discussion by professors Dr. Vera Albrecht and Dr. Shannon Proctor, who both teach the philosophy of law class in the Humanities Department. And all of the episodes for May It Please the Court are now available in a unique playlist on your YouTube archive. You should know that we began with the earliest cases. You heard Griswold versus State of Connecticut, which dealt with distribution of condoms, and worked up to Roe v. Wade and beyond. We would like to finish that series at some point. We've brought in Dr. Chelsea Del Rio from the Social Science Department, who has also talked about some of the recent developments. And as you heard Dr. Albrecht say, it was unexpected that we would find that the court would be arguing this case again. But here we are with the leaked document. The decision could come out soon and could change the landscape for reproductive rights, as well as how this country deals with its relationship with the highest court in the land. There is also some discussion in the impact that this may have on the midterm elections, which was mostly a case that people felt would deal with the economy. President Biden's handling the economy, and now the question becomes what happens if Congress is in the hands of the Republican Party completely, not to mention eventually the re-election of President Trump, and what impact this might have on the legal rights of women and as far as reproductive rights are concerned. So I just want to thank everybody for watching, for listening. I also want to thank our engineer, Mr. Pope. I think he and I we spent a lot of time watching this episode and seeing all the things we might have wanted to do differently if we'd had the time, particularly the PowerPoint. By the way, if you had watched shows afterwards, you would have seen that we did get better at doing the time signatures for the PowerPoints. And we just hope that this will serve the purpose that which is for students to watch them, for it to provoke an educated debate, discussion, whether in a critical thinking class, whether in medical ethics class, whether in the philosophy of law classes, whatever class it might be, and that LaGuardians in the future will be able to watch these, whether from the institutional archives or their own archives here at LaGuardia Web Radio WLGR. So again, I just want to thank you for watching. The show has been What's Going On. I'm your host, Hugo Fernandez, here on LaGuardia Web Radio. An encore session of May It Please the Court. Thanks for watching. Thanks for listening, and we'll see you next time.